Okay, so basically these are the topics, okay, we're going to touch, okay, in this legal maxim, qawaid fiqhiyya. Okay, the first is definition, okay, definitions of qawaid fiqhiyya. So then 5 major maxims, we will go through one by one, inshallah, the 5 major maxims. Okay, the first one is al-umur bimaqasidiha. Al-umur bimaqasidiha, yeah, you see, it consists of few words only, yeah? But actually the meaning is very comprehensive. Yeah, al-umur bimaqasid, 4 words or 2 words. Yeah, matters are determined according to intention. So meaning that all our deeds are determined, must based on the intentions, our niyyah. Yeah? And then the second one is hardship. Okay, hardship begets facility. Okay, hardship begets facility, or in Arabic we call al-mushakkah tajlib al-taysir. Okay, al-mushakkah, difficulty or hardships. Yeah? It's not the normal hardship. It's not the normal hardship that accompanies the implementations of the performance, okay, of every obligatory duty. Okay, but it is the hardship is beyond our capacity to perform the duty. Yeah, for example, hardships when we are sick. For example, hardship in travel. Okay, so that is the main. That is the main. Right? So then, harm shall not be inflicted. Okay, nor reciprocated. So this actually based on hadith. Yeah, so the origins of these legal maxims, okay, is actually from a hadith. Okay, Prophet Muhammad SAW said, okay, la darar wala dirar. Yeah? Okay, then the fourth one is what is certain cannot be removed by doubt. You know, something that is certain, okay, established certainty cannot be removed by doubt. Yeah? That comes later. So you must based on the certainty. Okay, al-yaqin la yazulu bi ashak. So this in Arabic. So next, custom is arbitrary. Okay, custom is arbitrary. Al-aada muhakkama. So al-aada, customs, yeah? Normal practice for a group of people, for example, okay, can be a reference, can be a judge, okay, to solve, okay, issues, any issue. Yeah. Okay, let's move. So the definitions of qawaid al-fiqhiyya, okay, so it is a legal maxims. Okay, qawaid fiqhiyya or legal maxims are general rules of fiqh. Yeah, so these legal maxims can be applied in various cases. They come that come under the common rulings. Yeah, so al-qawaid is the plural of qaida. Okay, al-qaida means principles. Yeah, plural. Rulers of this qaida. Okay, qawaid means principles. So fiqh, what does it mean? Okay, fiqh means Islamic law. So al-qawaid fiqhiyya, so it means the principles of Islamic law. Yeah, the principles of Islamic law. So we can refer to these principles in order to solve, okay, in order to know fiqh rulings. Yeah. Okay, so we can use these principles to deduce, okay, to deduce fiqh rulings or any rules of fiqh, right? So according to Mustafa Al-Zarqa, okay, he defined qawaid fiqhiyya as general fiqh principles, okay, which are presented in a simple format consisting of the general rules of Sharia in a particular field, okay, in a particular field related to it. So qawaid fiqhiyya is general principles which can be applied to various issues of fiqh and presented in simple format. So when Mustafa Al-Zarqa said it is, in simple format, consistence of the general rules. Okay, so simple format meaning that it consists of few words only. So let for example, like I said just now, okay, al-umur bimaqasidiha. Okay, hardship begets facility. It also consists of few words, but the meaning, okay, but the meaning is very comprehensive. Okay, it covers all aspects that any aspects pertaining to it. Yeah. To the principles. Okay, so the qawaid fiqhiyya is general principle which can be applied into various issues of fiqh and presented in simple format. Yeah, so meaning that it not covers all issues, okay, under this principle, okay, but it most issues, okay. So the issues that are not under any legal maxims is considered as an exception, okay, but it does not harm the authority of this legal maxim as the principles, okay, general principles of fiqh, okay. So we can still refer to these legal maxims. Okay, so many cases which occur can be referred to these maxims for solutions, and in many instances they can be the measurement. Okay, measurement for the validity of certain dates. Yeah. So, for example, the legal maxims that says injury. Okay, injury may not be met by injury. So this means that deeds, okay, which are harmful or will cause harm, okay, any kind of injury to others, any kind of harm to others, okay, must be avoided. Okay, so it can it can be the measurements, okay, of a certain deed. Okay. So meaning that the applications of this legal maxims, okay, injury may not be met by another injury, by injury. So this maxim is very wide, as it includes so many kinds of harm and injuries. Okay, so it covers all kinds of harm and injuries. Okay, so the next point is the qawaid al-fiqhiyya is general principles which covers most of the issues of fiqh. Okay, and not all of them. Okay, so not all of the issues. Okay, but most. Okay, most of the issues of fiqh. Yeah? Okay, so so the issues which do not come under any qaida of fiqh are considered as an exceptional, okay, which does not affect, okay, the authority of qawaid fiqhiyya as a whole, right? Okay, so we move to another slide. So this is the definitions of qawaid fiqhiyya. Okay, so we come to the first major legal maxim. Okay, the first legal maxim. Okay, al-umur bi maqasidiha. Al-umur bi maqasidiha, what does it mean? Okay, so actually it implies, okay, an act, all right. So an act of any human being is judged, okay, in the lights of the intentions or the purpose, in the purpose of it, okay, it seeks to have effect, okay, or the purpose it seeks to have effect, yeah. Okay, so this means that the effect to be given to deeds, to any particular deeds, to any particular action or transactions must be according to, or must be in accordance with the intent, okay, the intention or the intent underlying such actions or transactions. Okay, so the action, okay, must be based on the intention, okay, the intentions of the doer, for example. Yeah. Okay. So the origins, okay, where, okay, these legal maxims comes from. Okay, so it is actually from the hadith, okay, of the Prophet Muhammad sallallahu alaihi wasallam. Okay, so it was narrated by Umar radiallahu anhu. Okay, the Prophet sallallahu alaihi wasallam said, okay, deeds are judged by intentions, and every person is judged according to his intentions. So what does it mean? Okay, so the hadith clearly stated that, okay, all deeds, all actions, okay, are judged according to to the intentions, okay, according to the intention. So the illegal implications of the actions, the legal implications of the deed, okay, are also based on the intention. Okay, so later I will discuss, I will explain how, you know. Okay, so another basis, okay, narrated by Anas. Okay, narrated by Anas radiallahu anhu, the Prophet sallallahu alaihi wasallam, okay, is reported to have said, okay, there is no deed to those who have no intention. Okay, there is no deeds to those who have no intentions. Okay, so it's not accountable. Okay, I mean, it's not considered as ibadah, for example, yeah, because later on we see what is the purpose of intention is actually to differentiate between adah, the normal practice, the custom, and also the ibadah, and also to differentiate among the ibadah. Okay, to differentiate from one ibadah to another ibadah. Okay, so this is the purpose of intention. All right. Okay, so now, okay, we look at the applications of the maxim. Okay, al-umur bi maqasidiha. So if a person, okay, so this is the an example. Okay, if persons find something on the street and takes the object, okay, the judgment differs according to the intention. Okay, the illegal implication. Okay, the judgment is actually different based on the intention. Okay, so for example, if a person, okay, a person takes the object, okay, with the intention, okay, of returning it to the owner. Okay, so his conduct is in order and he is considered as the keeper. Amin. Okay, you see the implications. Okay, I'm the keeper of the item. Amin of the item. Okay, but if the person, okay, intends, okay, to keep the item as his own, okay, so he is considered as considered to be a person's wrongfully appropriating property of others. Okay, ghasib. Okay, so you see the implications. It's different based on the intention, even though the action is similar. Both actions are same. Okay, taking the items, okay, on the street, but then the intention is different. So the intentions are different, and the legal implications for both actions or deeds are also different. Okay, so another example is that, okay, if person kills another person, okay, if a person kills another person intentionally or unintentionally, so the judgment also differs, okay, based on the intentions of the perpetrator. Okay, so if the person, okay, kills another person intentionally, then the perpetrator, okay, should be given to death sentence, qisas, okay, if convicted. Okay, but if the crime is perpetrated unintentionally, the punishment is different. Okay, in which case the person need to pay blood money. Yeah? So because he kills unintentionally, so qisas, okay, will not be imposed on him, okay, or her, for example, okay, but he need to pay blood money, yeah, or diyah. So blood money is applied, okay, based on the intention. Okay, so yes, so this is the application. These are the application, the examples of applications for this legal maxim, al-umur bi maqasidiha. Okay, next. Okay, so before that, yeah. So that like I said, okay, the purpose. Yeah? So the purpose of, the intention, okay, the niyyah. So it's to differentiate between ibadah and also adah. Okay, adah, what does it mean? Okay, custom or personal habit. Yeah, to differentiate between these two things. Okay, so this is because some actions, okay, can be considered as personal habits if the actions are performed without a particular niyyah, okay, or without a proper intention, okay, to do it as a form of ibadah. Okay, so that's why we need a niyyah, okay, to have proper intention. Okay, for example, okay, if a person refrains himself, for example, from eating and drinking, okay, from Fajr until Maghrib, for example, until sunset, so without having the intentions of fasting, okay, so we cannot consider this this as a fasting, okay, because there is no intention, there is no niyyah. Okay, so this action is mere ada, okay, and will not be rewarded, right? Okay, if there is niyyah, okay, there is niyyah done with the, there is niyyah and intentions of fasting, so will be considered as ibadah, okay, and will be rewarded. Okay, similarly, if a person enters the mosque, and sits for the purpose of taking rest, okay, for taking a rest, so without having the intention to do i'tikaf, so his action is not considered as ibadah. Okay, but the same action with the intentions of i'tikaf, yes, okay, is considered as ibadah. Okay, so this is to differentiate, okay, between ibadah and ada, the customs or personal habit, right? And then the other one, another purpose, okay, the other role of niyyah is to differentiate between one kind of ibadah and another ibadah. Yeah, for example, in prayer, fasting, hajj, okay, and all that. Okay, there are different kinds of ibadah, okay, such as compulsory, okay, highly recommended, and all that. Okay, so this is actually why we need to have this intention to differentiate between an ibadah to one ibadah, one kind of ibadah and another ibadah. Okay, so next we move. Okay, branch of the maxims. Okay. So there is one maxims, okay, which are considered as the branch of this legal maxim, of this maxim al-umur bimaqasidiha. So the maxim rate, okay. In contracts, okay, effect is given to intention and meaning, not words and forms. Yeah, so in contracts, so the effect is we look at the intention and also the meaning. So let us look at this example. So for example, it is known as a hire contract. Okay, it is known as hire contract if a remuneration is stipulated for the use of a thing. Okay, use of a thing. Yeah, is a fraud. Okay, if you use, okay, if you put stipulate a remuneration for use of thing in a contract of loan, if there, okay, so we say we call this hire contract. Yeah, if we use a thing and then we pay a remuneration, so it is a hire contract. But loan, how? Okay, contract of loan, if there is no such stipulation, so we consider as contract of loan. So if two persons conclude a contract apparently of a loan, but on considerations for which the specific rental is provided for, okay, meaning that any stipulations of remuneration, okay, remuneration is stipulated, so the contract is regarded as hire contract. Yeah, because we look at the meaning, okay, we look at the intention and the meaning of a contract. Yeah, so even though says here concluded in a contract of a loan, but then need to pay rental, specific rentals for, so it's not a loan actually, yeah, but a hire contract, okay, based on the real meaning, because the meaning indicates, okay, not a loan, okay, even though the wording of the contract it looks like a loan, okay, but the meaning is not a loan, but it is a hire contract. Okay, so I hope you can understand this. Okay, the effect, in contracts, effect is given to intention and meaning, not the form and words. Yeah. Okay. Okay, so the second maxim, okay, hardship begets facility. Okay, al-masyaqqah tajlibu at-taysir. Tajlub at-taysir. Yeah. Okay, so hardship begets facility. Whenever there is hardships, so there is facility, there is way out. Okay, there is alternative. Okay, to remove the hardship. Okay, so the meaning, a general meaning of the maxim. So the maxim is actually actually indicates that any ruling, okay, whose implementation causes hardship to a person or the action is unable to be performed, okay, for a specific acceptable reason, okay, for a specific acceptable reason, then there are way out. There are alternatives, okay, that can be resorted to in order to overcome the hardship, in order to remove the hardships. Okay, so like I said, okay, hardship in this regard, okay, in this mazim refers to hardship that's beyond, okay, the normal limit, surpass the normal limit and ability of a person to perform this obligation, for example, to perform them, okay, such as hardship in travel, hardships of travel, for example, okay, hardship, or any sickness, okay, so difficulties in hardship, okay, so when we are sick, for example, it's difficult for us to perform prayers, for example, to go for Hajj, for example, yeah, so it is considered as hardship, okay, beyond the capacity, beyond our ability, okay, normal ability to perform it. So the normal hardship that accompanies implementations of every duty or every obligatory duty, okay, such as for example, normal hardship, okay, for example, hardship in performing prayers, okay, and performing a certain kind of ibadah such as fasting, Hajj, okay, so it is not regarded. They are not regarded in this mazhab, yeah. Okay, because okay, this kind of hardship is bearable. Okay, this kind of hardship is within the ability of person to tolerate it. Okay, so yeah. Okay, so the origins of the mazhab. Okay, so you can see, okay, there are several Quranic verses. Okay, several Quranic verses quoted in support of this mazhab. Okay, for example, in Surah Al-Hajj, okay, verse 78. Okay, so Allah says in the Quran, وَمَا جَعَلَ عَلَيْكُمْ فِي الدِّينِ مِنْ حَرَجٍ. Okay, so Allah did not make any difficulty for you regarding the religion. Okay, in Surah Al-Baqarah also 185, okay, verse 185. Okay, Allah says, okay, وَلَا يُرِيدُ بِكُمُ الْعُسْرَ. Okay, so Allah wants ease for you and He does not want hardship from you. Same goes to Surah Al-Baqarah, verse 286. Okay, so Allah says in the Quran, لَا يُكَلِّفُ اللَّهُ نَفْسًا إِلَّا وُسْعَهَا. So all these verses actually shows, okay, all these verses indicates that the fact that Allah subhanahu wa ta'ala does not intend to burden, okay, does not intend to burden humankind or human beings in all the injunctions that He revealed. Okay, so yes, therefore, if there is an injunction which is difficult to be performed, okay, for a valid reason, okay, then there will always be a way out. There always be an alternative, yeah? Okay, to remove, okay, the hardship, okay, as a way out, okay, from the hardship. Okay, so this is the origin of the mazhab. Okay, so now we look at the applications. Yeah, hardship begets facility. Okay, so the application, if someone enters a rental contract, okay, if someone enters a rental contract and later he must travel for a certain reason, so he is allowed to cancel the rental contract. So under a normal circumstance, okay, under a normal circumstance, it's not allowed. Okay, a person is not allowed to to cancel, okay, these types of contract. Okay, unless it is based on mutual agreement, unless it is agreed, okay, by any between the contracting parties. Okay, but because of this certain reason, so he is allowed to cancel the rental contract. Okay, because forcing a person to continue paying the rental when he is not occupying, okay, the premise, so this actually amount to hardship. So we need to remove the hardship. Therefore, the Sharia has allowed the cancellations of these types of contract under specific circumstances. Okay, this is yes, in order to avoid hardship. Okay, in order to remove hardship. Okay, so the second one is the general ruling, okay, related to the implementation. The general ruling, okay, related to implementations of punishment towards a criminal is it should be carried out immediately. Punishment it need to be carried out immediately upon a conviction if he is or she is convicted, okay, for a crime. Okay, however, for certain exceptional situations, such as a criminal, such as the criminal is sick, the punishments can be different. Okay, so because if we continue, okay, during the sickness, for example, so it amounts to hardship. Okay, it amounts to difficulties, hardship. So we need to remove, so we can defer, okay, the punishment. Okay. Okay, then branches of the maxim. Okay. Branches of the maxim. Necessity renders prohibited things permissible. Okay, so this means that prohibited things are allowed to be carried out under extreme circumstances, provided that there are no permissible alternatives. Okay, for example, a person is allowed to consume prohibited food. Okay, a person is allowed to to consume prohibited foods in order to survive. Okay, under extreme situations, provided that no other food is available. Okay, so necessity renders prohibited things permissible. Yeah, whenever there is no food, for example, halal food, for example, to eat. Okay, then it is allowed for you to eat prohibited foods. Okay, with the condition that there is no available food, that there is no there is no available halal food. Yeah. Okay, so this is in order to protect life. Okay, to remove the any hardship. Yeah. Okay, so let us move to the next maxim. Okay, harm shall not be inflicted. Okay, nor reciprocated. So this maxim is another maxim. Okay, so it governs many rulings of fiqh. Okay, as it is a general maxims which indicates the importance to remove all kinds of harms. Okay, all kinds of harms. Okay, so if you see here, okay, meaning, so actually this maxim is divided into two parts. Okay, so the first part, which is harm should not be inflicted. Okay, indicates that all kinds of harm should be avoided. Okay, any kinds of harms, okay, should be avoided. Okay, should not be inflicted. Okay, la darar. So even though it is involve individuals, if it is involve individuals, so it need to be avoided. Yeah, any harm that involves individuals, that involves society, that involves the environment. Okay, or other things, okay, shall be avoided. So any kinds of harms, okay, should be avoided. Okay, so the word harm, okay, is very general. Okay, so it includes, okay, all kinds of harms. Okay, all kinds of harms. Okay, kinds towards the society, like I said just now. All right, so all necessary measures, okay, need to be taken. Okay, need to be taken in order to remove these harms, okay, to prevent any kind of harm from occurring or from happening. Yeah. So yes, the second part is any harm that is inflicted, okay, should not be responded. Okay, should not be revenged. Okay, by inflicting another harm. Okay, so cannot do like that. Yeah, cannot do the same thing. Okay, if you are injured, okay, by someone, okay, so we cannot do the same thing. Okay, we cannot cause, okay, another injury to them. Okay, so why? Because this will add to the harm already inflicted, and also will cause or incur further harm. Okay, so in these situations, what we should do? Okay, so the person, okay, upon whom harm is done, so he or she shall demand his right through the process of law. Okay, through the due process of law. Yeah. Okay, so for example, if A damage the property of B, for example, intentionally, okay, so B cannot, under any circumstances, do the same thing, okay, or any cause damage, okay, the property of A, okay, we cannot do like that, okay, what to do? So he must get the compensations, okay, for the damages, okay, on his property through a court of law, okay, from the courts of law. Yeah? So that is the meaning. Yeah. Okay, the origins of the mazim, okay, derived from Surah Al-Baqarah, verse 185. Okay, Allah says in the Quran, okay, وَلَا تُلْقُوا بِأَيْدِيكُمْ إِلَى التَّهْلُكَةِ. Okay, make not your own hands contribute to destruction, okay, to your destruction. Okay, so la darar wala dirar. Okay, derived from the Prophet's sayings also, the Prophet's hadith. Okay, Prophet said, harm shall not be inflicted nor reciprocated. Okay, so meaning that, so Prophet said, okay, la darar wala dirar. Yeah? Yes, these are the origins, okay, where these maxims, okay, come from, yeah, from Surah Al-Baqarah, and also from the sayings of the Prophet, okay, sayings of Prophet Muhammad sallallahu alaihi wasallam, la darar wala dirar. Okay, let us move because the time is limited. Yeah. Okay. All right, so applications of this maxim. So driving recklessly, which might lead to an accident, is prohibited in Islam because it will cause harm to individuals and their property. So a person needs to follow traffic rules and regulations in order to prevent harm. Okay, so it's prohibited driving recklessly, okay, because it may cause injury, okay, may cause harm to other person, to other persons, or to the individuals. Okay, the second one, if anyone sells anything that wrote quickly and the buyer disappeared before the payment of the price and before receiving, okay, the sold items, okay, so the seller is allowed to revoke the sale contract and sell the said item to another person in order to prevent loss to the seller. Okay, so hardship, it is to prevent harm, okay, to prevent loss, yeah, to the seller. So it is allowed, okay, to sell the said item to another person, to another buyer. Okay, so branches of the maxims. Okay, branches of the maxim. Harm must be prevented wherever possible. Okay, harms must be prevented, okay, wherever possible. So this means that all necessary measures need to be taken. Okay, must be taken. Okay, in order to prevent any harm. Okay, any harm from occurring, any harm from happening. Okay, harm must be prevented, okay, wherever possible. All the necessary measures, okay, must be taken in order to prevent these harms, okay, from occurring. Okay, so the next one is greater harm must be prevented even at the expense of the lesser harm. Okay, so this the second maxim. This one, the second branch of this maxim. Okay, so indicates that, okay, in case there are two evils, okay, in case if there are two evils or between, okay, so the lesser evil can be committed, okay, in order to prevent the greater evil from occurring. Okay, so we can choose the lesser one. Okay, if there are two evils, so we can choose the lesser one, okay, in order to prevent the greater one. Okay, so that is the maxim. Okay, so you can commit the lesser one in order to prevent the greater evil, the greater harm, okay, from occurring. So in other words, it is choosing the lesser of two evils, okay, or any between two harmful things. Okay, we choose the lesser one. Okay, so yes, okay. So I hope you can understand, yeah. So this is these are the branches of the major mazhab, yeah. Okay, so next we move. Okay, so the fourth one, okay, what is certain cannot be removed by doubt. Okay, so al-yaqin la yazulu bi-shak. Okay, so what is the definition? Okay, a fact established by a law or proven with evidence will remain so. Okay, until there is another certainty that removes it. Okay, if just a doubt cannot remove, yeah, the doubt cannot remove this certainty, the established certainty. Okay, so any doubt that occurs, okay, any doubt that occurs when certainty prevails, okay, will have no power to remove the established certainty. Okay, so likewise, if something has not been established, okay, something has not been established with certainty, okay, so it will remain so. Okay, the situation is the situation remains so until proven otherwise. Okay, so meaning that doubt which comes later, okay, cannot remove the established certainty. Okay, this is because doubt, okay, which comes later is weaker. Okay, is weaker than certainty on which it's founded. Okay, so doubt therefore cannot contradict or resist certainty. Okay, so the origins of the mazhab, okay, we can find this okay, in Surah Yunus, okay, verse 36, yeah. Okay, so Allah says in the Quran, وَمَا يَتَّبِعُ أَكْثَارُهُمْ إِلَّا ظَنًّا. Okay, inna dhanna la yughni min al-haqqi shay'a. Okay, so it's about doubt. Yeah? Doubts cannot remove the established certainty. Okay, and also Prophet Muhammad sallallahu alaihi wasallam said, okay, if anyone of you feels anything in his or her stomach, and then he is confused of whether anything has come out or not, so he should not go out of the mosque unless he hears any sounds or gets any smell. Sahih Muslim, yeah. Okay, so the Prophet, this is in the hadith, yeah? Okay, so in explaining this hadith, Imam An-Nawawi said, okay, so he remarked that, okay, it is a great maxim of Islamic law, so the affair should be judged to be on their original conditions unless the opposite is certainly proved. Okay, so if any doubt, for example, okay, arise later, so these doubts would not hamper the certainty of the certainty that had been originally established. Okay, yes, yeah, so doubt that comes after the certainty, okay, so cannot remove the certainty, it remains so, yeah, unless it is proven. Okay, we move. All right.
Doctor?
Yes?
You have 3 minutes.
All right, inshallah. We can go fast, eh? So the applications of the mazhab, if a person is certain that he is in the state of ablution, so he is considered to have ablution until there is evidence showing otherwise. Yeah. So if you are certain that you're in the state of ablution, okay, so yes, you are in the state of ablution. Yeah. Okay, if a person has taken a loan from another person and it is doubt whether he's still in debt, so he is in debt until there is proof, okay, to show otherwise. Yeah. Okay, so branches of the mazhabs originally a matter will remain as it is. Okay, what is established by certainty cannot be removed except by certainty. So I hope you can understand it. Yeah? Okay, so the last one, okay, the last mazhab, okay, custom is arbitrary. Custom, ada. Okay, the practice of a certain group of people, for example, yeah, okay, practice of the people, okay, whether in their actions or saying, okay, so yeah, it's considered as custom. Okay, it's arbitrary, can be judged, can be referenced, okay, to solve a certain issue. Okay, so custom have the authority and can specify a general matter or restrict and unrestricted matter. Okay, so for instance, okay, if a contract does not specify, whether the delivery of the goods. Okay, the delivery of the goods is the responsibility of the seller of the responsibility of the purchaser. Okay, so we need to refer to the custom. Okay, we need to refer to the prevailing custom. Okay, so this custom should be depended upon. Okay, to specify and clarify. Okay, who should bear the responsibility to deliver the goods. Okay, all right, which is not cited in the contract. But if it is cited in the contract, so we need to refer, we need to follow the contract. Okay, so in this case, we cannot depend, okay, on the custom. Okay, if it is cited in a contract. All right. Okay, then the origins of the maxims, okay, in Surah Al-A'raf, you can find in Surah Al-A'raf, verse 199. Okay, so the Prophet also said, okay, take from his property what is customary, ma'ruf, which may suffice you and your children. Okay, so this is based on custom. Yeah. Okay, the nafkah, the maintenance. Okay, so you need to refer to your custom, okay, which may suffice you and your children. Okay, so basically this is the basis lah. Okay, so the applications of the maxim. Okay, the applications of the maxim. Okay, divisions of marriage dowry into two types. Yeah, so for example, the first is the dowry paid when the contract is concluded, and the second one is the dowry paid at a later period of time. Okay, so division of marriage dowry. So it's a based on customs, customs of certain people, for example, practices of certain groups of people. Okay. So the custom that involves transactions is the sale or buy al-ta'ati, which is normally concluded with the utterance acceptance. You say it is allowed, by al-ta'ati, without pronunciations, okay, of utterance acceptance. Okay, this is also practiced one. We also practice this by al-ta'ati nowadays. Okay, it is allowed, based on custom. So the use of certain words among certain groups of people, for example, in a university, for example, doctor, okay, we call this doctor, this person, okay, who has philosophy, degree, doctoral, any degree, who has a PhD, for example, okay, so based on certain, practice of certain people, a group of people. Okay, so branches of the maxim, a matter recognized by custom is regarded as though it were a contractual obligation. So custom can be regarded, okay, as a as a reference, okay, to solve any issue, okay, happen in the society. For example, we should base on the, the custom, okay, the normal practice of certain group of people, for example. Then effect is given to what is commonly known, okay, not to what happens infrequently. So custom, something that is commonly happen, frequently happen, not something that is not infrequently happen among the people. Okay, so this we cannot consider it as ada or custom. Okay, the custom. Okay, what is the condition? Must be any practice by all people, must be known, commonly known by people. All right. Okay, so effect is given to what is commonly known. Yeah. Okay, so next we move. I think we have finished the maxims. So since this is our last session, okay, introduction to Islamic Jurisprudence. So I give you some references for you to refer to add your knowledge, okay, to add your understanding, for example. Okay, so these are the reference you can see through my slides, okay. And then also the questions, I give you questions, okay, for you to try to answer these questions, okay. These are all I have explained to you, okay. Try to answer if you have time, okay. So I think we stop at this point. Okay, so thank you for all of you, and my apology for any weaknesses and forgiveness. I seek your forgiveness, okay, for any weaknesses that I've done. Yeah. So inshallah, I hope whatever I've shared with you, with all of you, okay, you can benefit. Okay, you can benefit from it. Yeah, from this knowledge, inshallah. So may Allah bless may Allah bless all of us, inshallah. So yes, sister, shukran. Assalamualaikum warahmatullahi wabarakatuh.